Hello everyone. Welcome to KPSC Kanooni Kaksha. I am Arindam Seth, a law student, and the topic of today's Kaksha is the rights and remedies of home buyers under RERA Act. The Real Estate Regulation and Development Act was passed by Parliament in 2016 with the aim to create an atmosphere of fair transaction and holistic dealings between the property purchaser and dealers of estates in India. Previously, the home buyers were affected by the defective services offered by the builders and had a little choice to approach either consumer forums or civil courts to seek the compensation or claim rectification of the mistakes by the promoters. While both of them consume very long period of times to the consumers. But with the effect of RERA Act, buyers now can have immediate relief. Every act has certain legislative intents. Similarly, RERA Act has been designed with the objective to regulate and promote the real estate sector and to ensure the transparent sale of real estate projects and to further protect the interest of the home buyers and to establish the appellate tribunal for hearing the claims in the field of real estate. With such a wide aim and objective, the Act covers all the development of the buildings, consisting of apartments as well as the commercial buildings, the conversion of existing buildings or parts thereof into apartments, for example, converting a bungalow or hotel into an apartment, and further the development of land into plots or apartments for the purpose of selling for the same. As a result, it is important to emphasize that the Act broad enough to include the development of the land or building, apartments, and plots. Furthermore, the Act applies to both residential as well as commercial buildings. It is important to note here a case Priyanka Takshashud versus Sunworld Residency Private Limited, whereby Delhi High Court clearly states that a dispute over a refund of money under a flat wire agreement from real estate developer is arbitrary in nature, and it is not prohibited by the presence of concurrent remedy under Real Estate Regulation Development Act 2016. A consumer case for deficiency of service and defects is also maintainable under this Act. Despite a wide range and ambit, this Act also has certain limitations. Promoter receives a completion of certificate for a real estate project before the effect of this Act or the purview of this Act. But the entire area of the land to be built is less than 500 square meters, and the total number of flats to be created, including the all phases, is less than 8. It is not covered under this Act. Done with the intention of renovation, repair, or redevelopment, it is then not covered under this Act. It is important to note that who is the home buyer under RERA Act. The term home buyer is not defined under RERA Act. Rather, the term allottee is defined under Section 2B of the RERA Act. Section 2B of the RERA Act states that an allottee is a person to whom the land, plot, apartment, building is sold. It can be a home buyer, it can be a purchaser of commercial property. Further, allottee also includes a first buyer who purchases the land, flats, or building directly from the promoter. Also includes a second buyer who purchases the land, flat, building from the original buyer. Now coming to the today's major point, that is rights home buyers. The rights of the home buyers majorly focused under Section 19. Section 19 Clause 1 states that information. It states that the home buyers have the right to request information about every aspect of the property they have purchased, including the sanction plan, layout plan with specification that have been approved by the appropriate authority. Moving on to the next section, Section 19, which empowers the allottees or the home buyer to know the stage available for project completion, including water sanitation, electricity, and other amenities and services as specified in the agreement for sale. The next section is Section 19 Clause 3, which states that right to claim possession. It states that the allottee has the right to claim possession of the property or such a flat, plot, or buildings, and the association of allottees has the right to claim possession of the common spaces as specified in the promoter's declaration. The next right is right to claim refunds under Section 19 Clause 4, which entitles the allottees to the interest and the compensation as a manner prescribed in the Act. Under 19 Clause 5, the right to claim documents has been stated. For acquisition of the land, relevant documents such as design, including those of the shared areas. Rights given under Section 14, there are other rights that has been decided by judicial interpretation. The rights under Section 14 is given to the allottees against the deviation from the sanction plan by the promoter. Furthermore, except for the changes in the statutory development expenses or dues, the amount paid by the allottees shall be mentioned in the model AFS. New imposition or increase in statutory development charges after the project completion, the buyer will not be liable for the same. If there is a deficiency in the title to the property on which the project is being constructed or has been developed, the allottee may seek compensation from the promoter, and any such claim is not precluded by any limitation law. As we all know, while there is a right, there is a remedy. So, RERA Act also prescribes the remedies to the allottees. Under Section 11, Clause 5, if a promoter unilaterally cancels the allotment without any valid cause, the allottee can approach to the RERA authority and complain for the same. Under Section 12, if the allottee incurred any loss or damage due to the information given in the advertisement or model of the apartments, the allottee is entitled to the compensation from the promoter in accordance with the Act, or the allottees are entitled to the refund to the entire money with the interest paid to the promoter by seeing the advertisement. Under Section 14, Clause 3, if there is a defect in structure or other defects or service in or amenities that has been guaranteed by the agreement within the 5 years of such possession, the allottees are provided with two options: either to ratify the defects within 30 days of such damages, or the allottee can entitle to the compensation if you refuses to ratify the same. Further, under Section 18, Clause 1, if the promoter fails to transfer or unable to grant possession of the flat, plot, or building in accordance with the sale agreement, then if the allottee wishes to withdraw or seek the refund, the promoter must refund the entire money. Or if the allottee does not want a withdrawal, he is entitled to the interest for each month of delay until the ownership is handed over completely. Under Section 18, Clause 2, if a loss incurred by the allottees as a result of defective title to the land, then the allottee entitled to the compensation from the promoter. And finally, under Section 18, Clause 3, if there is a failure from the promoter to meet any other responsibilities that has been guaranteed under this Act, the allottee can approach to the RERA authority and entitled to the compensation. If there is a remedy, then there has to be a procedure to enforce the same. Under Section 31 of the RERA Act, the allottee can approach to the RERA authority or to the adjudicating officer for any deviation from sanction plan and for seeking compensation. Under Section 20 of the RERA Act, the appropriate government shall appoint the RERA authority as well as an adjudicating officer. Any appeal from adjudicating officer or from the RERA authority lies to an appellate tribunal but has to be given within the 60 days. And thus, if the person is aggrieved from the appellate tribunal's decision, he can appeal to the High Court, but that has to be within the 60 days period. That is all for today's Kaksha. Thank you, everyone.